So with that said, I want to now turn it over to our wonderful host for today. This is Gina Calderon over from Rosetta and Company. Gina, please take it away, my friend.
Thank you, Jeff. And thank you everyone for joining us today, and welcome to the new edition of Community Insiders, a speaker series designed to empower board members, community managers, and industry leaders with essential insights for effective community management. My name is Gina Calderon, and I am the Association Services Director here at Rosetta and Company. Today's topic, we're going to learn about funding and construction projects and construction contracts, a CEU course that is going to be led by our attorney, Kirsten Hens, and Kay Bender Rembaugh. Our guest speaker this morning is going to be Jonathan Revival, a lending product manager at First Services Financial. Hi, Jonathan. Thank you for joining us today. Can you please tell us a little bit about yourself?
Sure. Thank you for having me here today. So I'm a loan manager here at First Service Financial. I've been with the company now almost 2 years. Prior to that, I was actually a property manager in New York for 5 years, which gives me good insight on kind of what the management faces and deals with. And along with my lending experience, it helps bridge the financial solutions that we're offering to our managed associations.
Thank you for that. So also today we have Carla Castro, which is Rosetta Manager's marketing manager, who will help me moderate the questions along with Jeff along the chat. For those of you that are not familiar with Rosetta and Company, we've been in business since 1986, and we are actually in our 40-year anniversary. And we are a full-service community service manager management firm located in Tampa. We actually have 9 offices throughout Florida. Whether your community is small or large, or you have whether you're a developer, we are here to help you. With our resources and dedication, we are committed to making sure your experience with us is the highest level of experience when it comes to property management. And with that, I'll hand it up to Kirsten to get us started.
Thank you, Gina. Good morning, everybody. Again, my name is Kirsten Hensa, and I am a partner and managing attorney of the West Coast office for the firm, which is located in Tampa. For those of you who are not familiar with the firm, we are an exclusive community association law firms, which means that we represent exclusively your condominium, your homeowners, and your cooperative association. So that is our bread and butter. That is our one and only practice area. We don't practice anything else other than community association law. We have a number of locations throughout the state. Our main office is in South Florida in Pompano Beach, but we do have offices also in Palm Beach Gardens, in the Orlando area, and then, of course, here in Tampa. We have about 26 attorneys throughout the state of Florida. And I've been practicing law going on 18 years, and I've been with the firm since 2010. All right, so let's see. Let me share my slides. I do want to just mention one thing while I'm sharing my slides. Jeff mentioned the credit requirements and who's going to get the credits today. The reason that the condominium board members will not be getting credits is simply because the statute just has different credit requirements for continuing education for condominiums, as well as for HOA. So it's not that we're not offering this class for credit for condo board members. It's just that the statute has a very specific continuing education class for condominium board members. We do offer it. So I encourage you to go on our website, look at our calendar of all the upcoming webinars, and sign up for free. All right. Jonathan, can you see my slides?
We can.
Okay.
Yeah.
All right. Very good. Thanks, Jeff. All right, let's here we go. First slide. All right. So we're talking about funding construction projects. So what kind of projects would you be looking at? Well, I mean, there's a host of projects, right? I've identified here just a number of the most common types of projects. Of course, you might have a list that's significantly longer than this. But for example, emergency mitigation, right? That typically is a costly undertaking. code compliance, 40-year recertification. That depends on the county you're in. You might have a 20-year inspection requirement in your county. Concrete restoration, that's typically also a very expensive undertaking, especially if you're in a high-rise condominium. Certainly fire, life safety code upgrades, replacement, substantial upgrades of building components, such as elevators and seawalls. Elevators is one of those items that sometimes for one reason or another doesn't even make it to the reserve schedule, which not clear why, but can be very costly if you're looking to modernize elevators. I mean, it could be anywhere from $300,000 to, and upwards. So just quickly, some of your source of funding will be your annual budget, reserves, special assessments, and then borrowing financing. And we'll talk in a little bit more detail in the next few slides on each of these ones. But I just want to point out, the annual budget, that will refer to your regular assessment. Very rarely will, construction projects or big projects be funded through regular assessments. Not unheard of, but it remains an option, right? If you have maybe a project that's less than $50,000 and you want to budget it for, upcoming year, that's certainly an option. All right, so reserves is typically going to be your at least initial source of funding, right? Hopefully by now everybody is aware of your obligations to not only reserve for the statutory reserve items that have been in the statute, at least for condominium associations for for as long as I can remember, but also the new requirements with the structural integrity reserve study. Okay. Now I'll break down in this slide, how you can use these reserves. There's different requirements for each. So in terms of CEUs, and again, this is only going to apply to condominiums. So associations existing before July 1st of 2022, which are controlled by unit owners, must have CEUs completed by December 31st of 2025 for each building that is 3 habitable stories or higher. And then once you complete your first CEUs, you have to do another one every 10 years thereafter. The statutory deadline for completing the CEUs was extended to December 31st of 2025. This was one of those legislative changes that took effect July 1st of 2025. That deadline has since come and gone. So hopefully you have completed that CEUs study. Now for non-CEUs reserves, remember the non-CEUs reserves, the statutory reserves for your building painting, your roof replacement, for paving, those never went away. They're in the statute. And for the non-CEUs components, you should have also done a study. And if you haven't done one recently, then strongly recommend you get one done so that the reserve specialist can inspect and evaluate your reserve items, and then can create your non-CEUs reserve schedule. Now, in terms of funding, so new changes went into effect July 1st of 2025. And the statute now provides that CEUs reserves may be funded by regular assessments, special assessments, lines of credit, and loans. And then a special assessment, line of credit, or loan requires the approval of a majority of the total voting interest of the association. Okay, so you've always had the ability to fund these reserves through regular assessments, but now the statute gives you other funding options: special assessments and line of credits and loans. Now, unit owner controlled associations that must have CEUs may also secure a line of credit or loan to fund capital expenses required by milestone inspections or CEUs. We'll talk about funding later on in the webinar, but I wanted to point this out, that this is language that was actually added in the statute July 1st of 2025. It's always been our opinion that the boards of associations, whether it's condominium or HOAs, you've always had the authority to borrow, right? And that comes from Chapter 617 of the Florida statute, which is a statute that governs not-for-profit corporations in the state of Florida. As you may know, you are a corporation after all. So you are not only governed by Chapter 617 of the Florida statute, but also either 718, 720, or 719. So you've always had that authority to borrow, but now it's codified, at least in Chapter 718. Now, the statute also changed July 1st of 2025, which now specifically addresses the pooling of reserves. So, in terms of accounting of your reserves, you have always had the option of having straight line accounting, right? So each reserve item has their own account. Now the statute says that you can pool your CEUs reserves, and you can also pool your non-CEUs reserves. You just cannot pool your CEUs and non-CEUs reserves together. So pooling essentially is taking two or more reserve accounts and then literally combining them in one account. Okay, so you might create a pool for your building painting and then roof replacement. And the flexibility that it offers board members in pooling reserves is that, let's say, you've been reserving for these pooled reserves for some time, but something's happened and you have to replace the roof of your building. Okay, you can't wait any longer, but you don't have all the funds in the reserve account yet. In the pooled reserve account, you have the option to then take reserve funds that have been allocated to building painting, in our example, and use it to fund the roof replacement. Now, at some point, you're going to have to, get your reserve study specialist involved to recalculate and get the painting and the roof reserves on track. But you have the option to essentially borrow, from another reserve line item without having to get membership approval. Okay, so that is the flexibility that reserve fund, the pooling reserves offers, especially if you're looking to do certain big projects. Now, the statute also in July 1st was modified to say that a vote of the members is not required for the board to change the accounting method for reserves to pooling account method, or from a straight line accounting method to a pooled account method. So what that means is that if the board decided today, going forward, you know what, we have straight line accounting method and we want to pool our reserves to have this flexibility in the future, that decision to pool going forward does not require membership approval. That is a board decision. You can do it at a board meeting. What is a little bit less clear in the statute at this time is if you already have reserve accounts, right, straight, and you have money, you have funded your reserves and you have money, and you now want to take all of the existing money and you want to pool it. So it's unclear whether the actual pooling of the existing reserve funds requires a membership vote. Okay, so if you're in that situation and you're looking to pool existing funds as opposed to starting pooling in the future, I would seek the advice of your legal counsel on that. Now, in terms of waiving or partially funding reserves, because that can provide you with some flexibility in funding some projects in the future. In terms of your CEUs reserves, the statute is very clear that associations that are required to have CEUs for budgets adopted on or after December 31st of 2024, you must fully fund those CEUs reserve items, and you do not have the option to have owners waive or partially fund the CEUs, okay? CEUs has to be fully funded going forward. Where you do have some flexibility is with the non-CEUs reserves, okay? Non-CEUs reserves, You may still give owners the option to either waive the non-CERS reserve funding or partially fund those non-CERS reserves. And the vote that you would need to get is a vote of the majority of the voting interest. It used to be a majority of quorum, but a couple of years ago, the statute changed to now make it a little bit more difficult for owners to waive or partially fund non-CERS reserves. So if you're in a situation where you have to fully fund CERS and you have projects coming up, right, and you don't want to necessarily fully fund your non-CERS reserves, and you want to maybe use some of the additional funding, or you're looking to adopt a special assessment and use those funds for some capital improvements, then you do have the option to give owners the opportunity to either waive or partially fund non-CERS. Whether or not you want to give owners that option for non-CERS reserves is completely a board decision. Okay. Now, in terms of using reserve funds allocated for specific reserve items and then using that for alternate purposes, again, for CERS reserves, budgets adopted after December 31st of 2024, you no longer have the option to use your CERS reserve funds for alternate purposes. So if you have all your, CERS reserves, okay, and you have a capital improvement project coming up, right, a seawall restoration or a concrete restoration, you no longer have the option of using those CERS reserve items to fund this project if you hadn't specifically reserved for it, okay? With non-CERS reserves, you have that option, okay? So the statute still allows members to vote to partially, to use non-CERS reserves for alternate purposes. But remember, I said members. So if you want to take any non-CERS reserve items that have been allocated for specific reserves, and you want to use them for alternate purposes to fund, for example, that capital improvement project that you didn't previously reserve for, you can do that, but you need to get the vote of the membership. And the vote that you need is a vote of the majority of the voting interest. Okay, it's no longer a majority of quorum, it's a majority of the voting interest. Okay. Oh, well, let me go through this slide and then I want to make a point about HOA reserves. With condominium reserves, these two bullet points are additional changes to Chapter 718 of the Florida statute that took effect July 1st of 2025. For budgets adopted on or before December 31st of 2028. If the association has completed a milestone inspection within the previous 2 calendar years, the board, upon the approval of a majority of the total voting interest, may temporarily pause for a period of no more than 2 consecutive annual budget, reserve fund contributions, or reduce the amount, reduce the amount of reserve funding for the purpose of funding repairs recommended by the milestone inspection. So if you've had your milestone inspection done and you have capital repairs that you have to do in accordance with your milestone report, this might be an option for you to either pause or reduce the funding of your CERS reserve so that you can allocate those funds towards the repairs. Now, if you do this, and I encourage you to get with legal counsel to properly do this, then you will need to have a CERS performed, another CERS, not necessarily the visual inspection part, but you'll need to get with your CERS, with your reserve specialist to reevaluate your reserve schedule to determine your reserve funding needs in the event you've suspended the CERS funding or you've reduced that funding. So your reserve specialist will have to recalculate your CERS going for the future. Now, if the association completes milestone inspection or an inspection completed by a similar local requirement, The association may delay the performance of the required CEUs to allow the association to focus its financial resources on completing repair and maintenance recommendations of the milestone. Okay. So again, another option, another flexibility to use your funding towards your capital repairs. Before I move on to special assessments, for HOAs, in terms of reserves, HOA requirements for reserves are a little bit different. The only way that an HOA would have what I'm referring to as these statutory reserves is if the membership approved establishing these types of reserves. Typically, more often than not, when board members use the word reserves, they're really talking about, contingency funds, setting up a line item, for, an emergency fund or a contingency fund in case something unexpected comes up. That in and of itself is not necessarily a statutory reserve, because if it is a statutory reserve and one that has been established by the membership, okay, then you will be restricted in how you use those reserves, similarly to how condominiums are restricted. You wouldn't be able to just, you would have to fund those reserves unless owners vote to waive or partially fund. And you wouldn't be able to use these reserve funds for alternate purposes unless the members approve it. Okay, so if you have any questions whether or not what you call reserves are in fact statutory reserves, then I would get with legal counsel to review and then evaluate whether or not you are restricted in how you use those reserve funds. If they're not statutory reserves, then they're nothing more than operating funds, which means you can use them for any bona fide association expense, such as capital improvements. All right, let me quickly move on to special assessments. That is going to be another source of your funding, and sometimes your main one. So if you are looking to adopt a special assessment to whether to pay for the entire project or for just additional funds, if you don't have enough in reserves, be very careful to notice your meeting at which you're going to adopt the special assessment in accordance with the statute. Okay, so both 718 and 720 and the cooperative statute 719 are very clear on what your notice needs to include. Okay, so the notice of the board meeting must specifically state that the special assessment will be considered and must provide the estimated cost and a description of the purpose of the special assessment. Okay, and again, estimated cost doesn't have to be down to, to the penny. I mean, if you know it, that's great. But often with, big projects, there's, things do come up. So an estimated cost is what you would need to include on the notice. The notice also has to be provided to the owners in a specific manner. Okay, you need to follow the statute, and the statute says at least 14 days prior to the meeting, you have to either mail, hand deliver, or email the notice to those owners who have consented to receiving notices by email. You'd have to give them this notice of the special assessment, and you have to post the notice on a conspicuous in a conspicuous place 14 days prior to the meeting. Now, evidence of complying with this requirement has to be made by an affidavit. So typically either the secretary or property manager would need to sign an affidavit attesting that the notice was timely and properly provided to the owners. If you don't comply with these statutory notice requirements, and let's say down the road an owner doesn't pay their portion of the special assessment and you try to pursue collections, that owner would have a basis to challenge your collection action. Okay, so if you have any doubts, get with your legal counsel. Limitation in the governing documents. I want to point out this necessary maintenance exception because this comes up very often when a board member finds a provision in the governing documents, typically in the bylaws, that says if the board needs to adopt a special assessment, and sometimes there's a dollar threshold, and the special assessment exceeds that dollar threshold, then membership approval is required. There is case law that stands for the proposition that if this special assessment is being adopted in connection with a necessary maintenance obligation of the association, so if the roof needs to be replaced, if concrete restoration needs to be done, if the seawall needs to be restored, in other words, a necessary maintenance obligation, then the board can adopt that special assessment without membership approval. And even if owners are against that, they're still required to pay. Okay. Very different from material alteration, which I'm not really going to talk about here. This is only in connection with adopting a special assessment in connection with a necessary maintenance project. Once you've adopted the special assessment, I would encourage you to also get with your legal counsel to help you draft the motion that you're going to be adopting at that meeting, right? So that motion will eventually make its way to the minutes of the meeting, which should contain the payment terms of the special assessment, so that down the road, when you do pursue collection action, the terms of the repayment are set in your minutes. Okay. And then lastly, borrowing and financing. So I'm only going to, just quickly highlight, on the legal side of this, and then Jonathan's going to talk a little bit in more detail about the actual logistics of it. So the board has the discretion of whether or not the association will borrow funds for a project, right? That is a board decision. You decide whether you want to fund it with just special assessments. If you don't want to put too much financial strain on your owners and you want to explore some borrowing options, which might give you a little bit of breathing space for owners to repay, that is okay too. Purely a board decision. Authority for the association to incur debt. I mentioned earlier in the webinar that the source of your authority to borrow will come from Chapter 617 of the Florida statute, right? Recently, of course, Chapter 718 has also codified authority for the association to borrow. Now, whether or not borrowing is going to be a board decision or will require membership approval, that is going to depend on your governing documents. Okay, so if the board is considering borrowing, you'll want to get with legal counsel, and you want to get legal counsel involved early in the process to, among other things, confirm whether membership approval is required. And if membership approval is required for you to borrow funds, guess what? There are no exceptions in the law to that requirement. Then you will need to get that membership approval, because one of the conditions to the bank loaning you money is that your legal counsel is going to have to sign a letter attesting that you have gone and fulfilled all of your obligations to borrow the funds. Okay, and one of the requirements would be if you are required to get membership approval. So that's what I'm saying. Get your legal counsel involved early on, not on the tail end of your borrowing process. Have legal counsel assist with your notice package for the meeting at which you're going to borrow. Okay. Because at the same meeting that you're going to be adopting the same meeting that you're going to be approving the borrowing of the funds will likely be the same meeting that you will also have to adopt your special assessment to repay the funds borrowed, right? Because they need to be repaid somehow, and that is typically done through a special assessment. So your motion, among other things, should specify your loan amount, the name of your lender, the interest rate, the repayment terms, the term of the loan, the details of the renovation project, and so forth. So again, really encourage you to get with legal counsel early on in this process. I also just want to just highlight some of the documents that might be involved in your loan process, and this is my last slide. So commitment letter. A commitment letter is a formal binding agreement between the lender and the borrower. It will outline the terms and conditions of the loan and the nature of the prospective loan. It basically serves as the agreement that initiates an official loan borrowing process. So if you've signed your commitment letter without your legal counsels involved, there's really not going to be much opportunity for you to renegotiate these terms later on. So you want to get your legal counsel involved and review your commitment letter before you sign, because once you sign it, that letter is what is used to draft the loan documents and the terms. You want to ensure that the terms of your loan are accurate. There's notice and opportunity to cure. You want to look for prepayment penalties and make sure you understand those and agree those. There's going to be a collateral assignment of rights. So when you borrow funds, you're not giving the unit of unit owners as collateral in case there's a default, right? So the bank is not going to come and foreclose on the units. What you are giving to the bank is you're signing the rights to collect assessments. Okay. So if you default, then the bank's going to collect assessments, and you want to make sure that the collateral, the assessments, it's narrowly tailored. So you should only be giving an assignment of assessments to the bank, not other types of funding like your reserves. Some closing documents that you can expect to include involve minutes of meetings approving the loan, the special assessment, the project, board resolutions, borrower counsel's legal opinion. That's that letter I told you where your legal counsel has to basically sign off that the association has met all their legal requirements to borrow the funds. There'll be insurance documents involved, certainly association governing documents. And then contract with your contractor, engineer, your plan specification. That's all going to be part of your closing documents. Some closing costs that you might expect, certainly association counsel fees. There's going to be a recording as well as documentary stamps, origination fees, and you might also be responsible for the lender's counsel fees. Okay. So I'm done with these slides, and I will let Jonathan take it from here.
Thank you, Kirsten. Before we get to Jonathan, we do have one question on the chat that we will get to the end. But before we get to the questions, we're going to go ahead and learn more about those loan options that are available to homeowners and actually associations. So John, please teach us more.
Sure. Thank you, Kirsten. Thank you, Gina. That was a great presentation. Hard for me to follow that because you covered all the whole process on the loans. But again, I'm going to reintroduce myself. I'll give you guys a little bit of a background about who we are here at First Service Financial and how we can help your associations. So my name is Jonathan Rabibo. I'm a loan manager here at First Service Financial. Jordan Muchnick, our Vice President of Lending, was originally scheduled to present today, but due to a scheduling conflict, he was unable to attend. So First Service Financial is essentially the financial arm of our property management company, First Service Residential. Our focus is on providing value-add services to our managed communities across three primary areas: deposit services, insurance, and lending. So on the lending side, we originate, negotiate, and close around $600 million annually in loans, primarily for condominium and homeowner associations across the U.S. These loans typically include operating and emergency line of credits, term loans, refinances, all tied to capital projects and long-term planning. So we're extremely active in this space. In fact, I like to say we place more associations loans annually than many banks do on their own. And because of that scale and because of the network that we work with many of these lenders in these institutions across both lending and deposit sides of the business, we maintain these relationships with them. And this allows us to secure best-in-class rates, favorable terms, and flexible structures for the communities that we serve. So we feel these terms and conditions that are often more advantageous than what these lenders would offer directly without our involvement. While most of the loans and the activity on the lending side is concentrated within communities managed by First Service Residential and Rosetta and Company, we're also open to working with other associations outside of our network. So, like I mentioned before, I have experience on the management side. Jordan Muchlik has experience in running our lending group. We have a very good knowledge base on how these condominium and homeowner associations loans work. We meet with board members and management teams to help strategize what kind of funding they need. Like I said, there's emergency line of credits, term loans, line of credits. So we help narrow down those decisions and help how they can plan future. And I think that, some of the important points that Kirsten made before is that, just like she's mentioning to get your attorneys involved early, I think the same thing goes for us on the lending side. The earlier you're planning, the earlier you're getting ahead of this, the more resources and knowledge you have to make a decision on how you want to fund your capital projects. Sometimes it may end in a loan, and sometimes we met with associations that a loan may not make sense for them, but they wouldn't have reached that point without having these open discussions and understanding how these loans are structured. These loans are unique, and it's a very niche market of banks that operate in this lending market. Because to the point that was made earlier about the collateral, not many banks want to take on this kind of collateral on their books for these loans. So there is a very limited number of banks that do play in this space. I think another thing to note was, that aside from the planning, these loans typically from submission of application take about 60 days from application to closing. You have to factor gathering terms, reviewing those terms, signing off on that prior to those 60 days. And then within those 60 days, you also have to factor the time on getting your membership approval, your legal opinion letter, gathering the documents. So there's a lot that goes on behind it. On our side, like I said, we help in facilitating and bringing in these better terms and rates and structures for our associations that we work with, but we also quarterback the whole process from the initial discussions all the way to closing. So, with our management company, we're embedded within the management company, so we have access to the documents to be able to pull them and provide them to the bank, but we're also experienced in navigating and pre-checking what it's going to be needed for these types of loans so we can get them ahead with even external management companies that we work with. I think I've covered most of it and given you guys a good rundown. I'll turn it back to Gina or to see if there are any questions.
Thank you so much. That was actually really well done. So now we're going to go ahead and take it to the Q&A, and I do have 3 questions. The first question is coming from Jonathan. Thank you, Jonathan, for joining us. And your question reads, if you are already in a construction project and you are falling short on reserves, do you need a vote of the majority of the voting interest to collect the funds needed as a special assessment? And I will say, Kirsten, can you please answer that?
Sure. So if you're already in the middle of the project, and I presume you're using all your reserve funds and there's a shortfall, then it sounds like you will need to adopt a special assessment. Now, remember I mentioned that to adopt a special assessment for a necessary maintenance project, you don't need membership approval, certainly not in the statute. And if you do have anything in your governing documents requiring membership approval for special assessments, the case law provides otherwise. So you go ahead as a board, you adopt your special assessment, make sure you follow the statutory notice procedures, have your property manager, your legal counsel assist with that, and then make sure you include the terms of repayment, right? So if you're needing these special assessments to pay for the project or the contractor is not going to perform the work, then obviously, the payment schedule is going to be a little sooner rather than later. So that's obviously a consideration.
Thank you, Kirsten. So the second question, first, Jonathan, did that answer your question? Or did you have any other question, Jonathan? Please just type it in the chat.
And folks, I just
I
want to
think
clarify
Jonathan got it.
before they continue, two different things. There's a chat module and a Q&A module. So any course related questions for Kirsten and Jonathan or anybody on the Rosetta team, please use the Q&A module. The chat module is different. That's where we're placing and have already placed the link for the required evaluation, and I will do so again in just a moment. Back to you, ladies. And Jonathan?
Right, perfect. So let's go ahead and take it to our second question, and it comes from Karen. And her question is, if 2 or 3 owners do not pay their portion of the loan, how does the bank collect? And I would take that to our guest speaker with First Service.
Sure. So if a resident is not paying their loan or their special assessment portion, essentially your general collection process for regular assessment dues is put into place. The bank does not come in and collect those funds. The bank only steps in if the association defaults on the loan. Remember, the association is the one taking out the loan, not the individual. The special assessments are a payment vehicle tied to the loan. So when someone is not paying, or 1 or 2 owners are not paying their dues or their special assessment, it's the general collection process that your association has to collect those dues.
That's
Thank you so much,
correct.
Jonathan.
That's correct, Jonathan. Remember, you have to adopt a special assessment to repay that loan if you end up borrowing, right? Your special assessment meeting minutes is going to outline the terms of the special assessment. So if 2 or 3 owners are not paying your special assessment, you're going to proceed through your typical, collection process, and I presume at some point, turn it over to legal counsel for collection. It's only when the association itself does not pay the bank that the bank might step in.
Thank you, Kirsten and Jonathan. So, Karen, did that answer your question? She's not responding, so we're going to go ahead and take it to Bonita. So, Bonita is our third question, and her question is, the CEUs milestone, or HOA, is not for 3-story, but we are condos. Does the requirement affect us? And I would say, let's take that to Kirsten.
Yes. So no, if you're not in a condominium that has at least 3 habitable stories or higher, then CEUs and milestone requirements do not apply to you. Period.
Thank you. Okay, so now we're going to go ahead and take it to Andrew. And his question is, what collateral do you take for the loan? Jonathan, please.
Sure. So the collateral for the loan, as mentioned before, is the assessment rights for the association. So essentially, the assessment revenue that the association collects is your collateral. In the event, I could say this confidently, in the history of condominium lending and homeowner association lending, there has never been an association that has defaulted on a loan, knock on wood. In the event that does happen, like I said, they come in and take over the assessment. So they'll take over the lockbox where assessments are due. They'll collect what the bank is owed for their portion and disperse the rest back to the building. Kirsten, correct me if I'm missing anything on that aspect, but I think, to our knowledge, that's what it is.
Yeah.
And Michael, you're not going to see any of the questions. Only the panelists can see the questions, but we're answering them aloud. Back to you, Gina.
I think we're on Susanna.
So the next question, reserves be invested in. Let me repeat the question from Susanna. So the question, portion of reserves be invested in CDs?
Yes.
And let's go ahead and take that to Jonathan.
Reserves can be invested in CDs. I'm not as experienced as much as our cash management side because I focus primarily on lending. But with interest and requests, I can certainly bring that up with them further. But to my knowledge, you are able to put it into a CD account.
Mm-hmm.
Thank you. So John, his question is, how are you structure lending processes more favorable than bank loans? Could you give a specific example of your benefits? So what's the difference between you and a bank?
Sure. So we're essentially, think of us as kind of brokers. We work in between the banks, but we have a large deposit business side to for Service Financial, where we're investing reserves and some money that associations put aside between our whole portfolio. So under cash management, we have about $9 billion under management that's invested for our clients across our partner banks. And those same partner banks work with us on the lending side. So between the $650 million in loans we do, along with the $9 billion that we have invested with these banks, they value our business very heavily. So think of us as kind of the Costco in this industry. So we're getting preferred pricing versus versus a manager approaching a bank directly or a board member approaching a bank directly. We're getting these preferred pricings because of the business that we hold with them.
Thank you, Jonathan. Okay, so our next question is, for road paving, can the board open a separate reserve in the new budget for long-term planning? And I would say, let's go to Kirsten for that answer.
Yeah. I mean, certainly if you're in a condominium, you absolutely have to include road paving as part of your reserve. Okay. And that's part of the non-CEUs reserve. So that's statutorily required. If you're in an HOA, and it's not clear from the question whether or not you are in an HOA or in condo, with HOAs, you can always add an additional line item on your budget. You don't even have to call it reserve. I mean, you just call it, road paving, and then, collect assessments, as part of your budget.
Thank you, Kirsten. So the next question comes from Thales, and her question is, I have a concern. We have an open permit for sprinklers, retrofit for a couple of years. And now to close the permit, some repairs and new installations are required from the fire department. Can I use CEUs to cover for these additional installations of heads and repairs in her current system? Can she use her CEUs funds to conduct the repairs?
Well, remember that CEUs reserve funds can only be used for the particular item for which that reserve was earmarked for.
Yeah.
So if you have a reserve line item that is specifically for fireproofing your life safety systems, I would speak with your legal counsel whether the particular repairs at issue here, and I don't know the details of them, would fall under that category. Otherwise, you can't use reserve funds for alternate purposes.
Thank you, Kirsten. So our next question reads like this. It comes from Chuck, and he says, Jonathan, what is your average fee for providing your services?
Great question. So our standard average fee is 1% of the loan amount. To touch a little bit also on before, in general, we're saving anywhere between 0.5% to 1% off an interest rate when we're brought in to be involved, along with lower closing costs. So our fee generally is one-time fee paid at closing. And I would say at the minimum, it's the savings that we're generating is 6 times the amount of our fee.
Thank you. Okay, so the next question comes from Ronald. And his question is, repairs to elevators can come from these reserves? Can he use the repair, to repair the elevators?
I presume that there is a line item for elevators. I think it's going to depend on how that line item reads. So I would definitely follow up with your legal counsel on whether that particular reserve can be used for your repairs.
Thank you. So the next question reads, if a special assessment is approved for residents, not loan related, is attorney then consulted on the next step, just like failure to pay your HOA dues?
Well, I mean, if you're adopting a special assessment unrelated to a loan, I would still seek legal guidance to make sure that your notice is properly prepared, that you know the steps of, the advance notice that you need to give to owners, the type of motion that you need to adopt, to make sure that your minutes accurately reflect the term of your special assessment. Um, at the end of the day, I think board members forget that you are running a corporation, right? Your association is an entity, it's a corporation. And so you should be relying on your experts, right? Your property managers, your legal counsel, your engineers, your CPAs. Rely on them to guide you on how to properly operate your association.
Thank you. So the next question comes from Robert, and his question is, he's specifying that he's an HOA. I'm assuming 720, but we don't have that clarification there. And he's saying he has 45 assets, including roads and pool funds. Can we shift the funding for the roads to straight line and keep the other 44 in pool? Does changing require a community vote? What about deciding how much money to shift to the road reserve? Thanks. So
Oh
he's
gosh.
wanting to have pool and straight line reserves. Is that possible, Kirsten?
These are becoming a little bit more detailed and complicated to answer on the top.
Yeah, it will help to actually identify some.
You can always, if you have straight line, you can always go into pooling, and if you have pooling, you can always go back to straight line. Does changing it require a community vote? For HOAs, I would say that yes, that if you've never pooled and you want to pool and vice versa, I would get the approval of the membership, because you are basically shifting, you're changing the use of the reserves. And so for that, membership approval would be required. But I would follow up with your legal counsel on these specifics.
Thank you, Robert, for the question. Actually, a really good question. So the next one comes from Sarah, and her question is a membership vote required to invest in a CD? And Jonathan, can you please answer that?
I'm not sure about that. I think it would depend on your bylaws, but I would definitely, I can ask our internal team and can get back to you. But generally, I don't think you need a membership vote. I think it's just on a board level.
You don't, and correct me if that's correct, Kirsten. There's no membership vote
Yeah, I mean,
required for CD.
typically, yes. And for Chapter 7, under Chapter 718, I believe that was one of the recent statutory changes, that you can invest in CDs without membership approval. So it becomes a business decision of the board, but I would strongly advise board members to consult with your financial expert, right? Your volunteer board members, you're not expected to be financial experts. So in terms of investment and prudent investment choices, speak with your financial experts.
Thank you. Okay, so the next question comes from Susanna, and her question is, Susanna is in a sub HOA association. Does members have to vote on the road paving reserve? So it depends if they have different budgets, right? Kirsten, go ahead and help me out.
Yeah, I don't even know what she's really asking.
So the sub association usually will have two different budgets. We have the master budget, and then we'll have a different budget for the sub association. So it depends whether that pavement line item is on that budget or not. So but if you are included in the master association, then we'll have to take a look at the bylaws to find out whether you have to review those or not. Is that correct?
Yeah, I'm unclear if she's asking whether you're trying to establish a statutory reserve. I mean, if you are establishing a statutory reserve, membership approval is required for HOAs. If you're just asking, can we just add a line item for paving? Typically that's a board decision, because boards adopt budgets. So I would follow up with your legal counsel on that.
Thank you. So the next one comes from Gerald, and the question is, are there any protections provided to prevent the use of reserve funds, save for a specific purpose, such as a hurricane recovery for other expenses? Kirsten, please.
So, I mean, if the question is, boards are using, reserve funds for alternate purposes, in violation of Florida statute, I mean, you always, owners always have the division of condominium to file a complaint, right? And if you file a complaint on this particular financial issue, which the division does have jurisdiction, then they obviously will investigate. And if there is a violation of the sort, then the association could be subject to monetary penalties. So I would say that's the recourse here.
Okay, thank you. So the next question comes from Kenneth, and his question is, we are considering construction of a new entrance way to our street. When the new board was in place, we saw that they had very little reserve. We would have to do an assessment. We could push the project off in an effort to fund the project better earlier than a very large assessment. Would a special assessment be best? Would we have to go through the efforts that we were outlined, or simply let the homeowners know? So he's basically asking, what's the best route, whether they should go for special assessments or not, and trying to fund a project that they have now planned for.
Yeah. I mean, there's a lot of variables, right? And they know their community better than I do. Is this project, an immediate thing? Is it absolutely necessary for you to get it done now without the funding? Is this something that you can push and then, collect it through your assessments? So I think just, having the board discuss the variables and kind of planning it ahead is probably the best option. And then, decide at that point whether a special assessment, maybe even just partially fund, maybe not fund the whole thing, but just partially fund would be in the best interest. Ultimately, it's a business decision.
Yeah, it takes a lot of planning. Planning is, for during your budget season will help that. Okay, so let's go ahead and take it. I'm just going to read this from Susanna. She's very excited. She's thanking you all for the awesome session. She's learning a lot. So that makes us feel good. Thank you, Susanna. So the next one comes from Kevin, and he's saying that he's in an HOA with established reserves, considering setting up another reserve item for emergency expenses like hurricanes cleanup. Can we, as the board, add such item without community approval? Kirsten, please answer that.
I don't know what established reserves are, because remember, HOAs are a little bit, they're trickier on the issue of reserves. You need to have had a membership vote in order to establish reserves. I, to be honest, don't even know why you would need a reserve for emergency expenses, because, emergencies happen all the time. Hurricanes can happen. I would just add it as a line item.
As a line item on your budget,
on your budget,
Kevin, that's what I would
contingency
actually,
funding. Yeah.
Yeah, just have
Why
a line
tie
item
it? Yeah.
every year you just fund that little bucket, and
Exactly,
you just use it
as an
needed,
operating as opposed
and
to
it'll
reserve.
grow. I would consider the best approach too. So the next question comes from Louis, and his question is it best to keep our reserves in short-term or long-term accounts in longer period, earn better rates, but it tightens the funds? Is it best to keep our reserves in short-term or long-term accounts in longer period, earn better rates, but tie the funds? Jonathan, can you help us with that?
I would say that it really depends on your usage and when you're going to need access to those funds. Usually our team internally, they will work with the management team based off their reports and when they need to know that they need access to those funds, and they'll stagger different CD accounts so that they can have access to it. But again, it really comes down to kind of the usage and how soon you need that. And that would depend on how long and how short you can push CCDs.
That makes sense. Thank you, Jonathan. Okay, so the next question reads, we recently updated our reserve study and have pool reserves. Most of the community formally approved the updated study, including changes to line items, estimated cost, and remaining life. So I am not sure here. We've recently updated our reserve study and have pulled reserves. Most of the community formally approved this updated study, including changes to the line items, estimated cost, and remaining life. I'm not sure what the question is right there. Do you guys?
I think if you're saying, if you're saying that you're getting together with your reserve specialist in order to update the study to look at these numbers, I think that is a board decision, especially if you have pooled reserves. So that's more of you basically updating your SURF study. That should not involve membership approval.
Okay, so we're gonna go to a couple of more questions here because we only have 5 more minutes left. So let's go ahead and take it to Michael. And his question is there any tax liability if you have CDs for some of your line items reserves? And we don't have a tax expert
I
here.
would
Kirsten,
defer
can
to
you
your accountant.
assist, or we want to skip that one? Yeah, I would say just contact your CPA and they'll be able to assist you with that answer, Michael. The next question comes from Susanna. For clarification, our HOA sub-association owns the budget and road paving in our community. It is our responsibility. Can we just add the line item reserved for paving, Kirsten?
Well,
She wants
again,
to add a new line item, basically. That's what she's saying.
yeah, I mean, you can always add a line item to your budget for paving, right? You don't need necessarily, need to establish the statutory reserve. So to establish a statutory reserve line item, you need to have membership approval. Okay. If not, it's an operating expense.
Okay. We're going to go ahead and take one more because Kirsten does have to leave us. So let's go ahead and take it to the last question. Rosary paving. Okay. So let's go to Cindy. If our condo association has a large CEUs project upcoming and adopts a partial special assessments along with the balance funded by the loan, once the loan is repaid in 5 years, can the association continue collecting the special assessment funds for building the reserves in anticipation of the next large CEUs project? Basically, we have a project, we fund it, can we continue to collect funds?
Not you can't continue collecting this special assessment for another purpose. It sounds like you're talking about using the same special assessment to now shift it to another purpose. You wouldn't. That would have to be, two separate special assessments. Because remember, you can only use special assessments for the purpose for which you adopted. So once you've adopted the special assessment for this project and the project is complete, that's it. You shouldn't be collecting any more special assessments as to that particular project.
Okay. Thank you. So I apologize for the questions that I couldn't get to it, but this is going to conclude our section of our question and answer. For this presentation, I want to thank Kirsten. I want to thank Jonathan. I want to thank Jeff and of course Carla for preparing this. It's actually very educational and we learned a lot today. Thank you everybody that participated and for all the questions that you submitted. They were actually great questions. So this would actually bring us to an end. I just wanted to let everybody know that these slides will be available in our website at resetta.com. It will be on Vimeo and YouTube channels within the next 72 hours. If you are looking for a new management company, feel free to reach out. We are here to help you reserve your community challenge and to guide you to the best of our abilities and let you know what's the right way to manage and establish a bond between homeowners, board of directors, your vendors, and everything that it comes with an HOA. Thank you for attending and investing your time with learning with us with Kirsten and Jeff and Jonathan. And have a wonderful rest of your day.
Thank you, Gina.
Thank you.
Thank you all.
Gina, before you head out, I have a question that may benefit several of our attendees. Let's say somebody is very, very happy with their management company and they're not shopping, but they may want a third-party consultant to make sure that they're not getting, for lack of a better term, screwed on something or whatever. Can they hire Rosetta, no matter where they are in the state, as sort of like a third-party consultant to say, hey, our company gave us this. What do you think of it? Is that something you guys do for anybody in the state if they want to?
So our contact person for that will be Taylor. And
Okay.
yes, we do. I mean, we do that actually all the time. So we get contacted by different different associations that they actually they reach out to us, letting us we're encountering this issue, and we want to find out how you can actually help us, if maybe the opportunity for us to learn more about Reseda and Company. We
Excellent.
usually don't charge for that, so we will actually come to you and let you know what we offer and see if we actually are a good match. Finding a property management company is like finding a good boyfriend, let's put it that way. They're very difficult to find. So finding a
Yeah,
manager, finding that company that's going to meet your needs is so important. And it's all about banding and learning about your communities. So we're here to help. Don't hesitate to contact us. Even though we're not your management company, we've been in business for over 40 years. And we grow, and we go based on referrals. That's how we grow our business. That's why we've been in business for so long. So
there you
thank
go.
you.
Thank you very much. And the same can be said for K. Bender Rembaum. That's how I found this wonderful firm many years ago when I was out in the field. We do it all. So I want to thank everybody for attending today. Kirsten, before you head out, do you have any parting words for everybody? All good to go?
Just thank you so much. You can always find my contact information on the firm website. It's a great resource. And I encourage everyone to go on our calendar. We have so many webinars, in-person seminars in the area, and they're all for free. All free legal education.
Client
Thank
or
you,
not.
everybody on the panel.
Take care, Kirsten. I know, Kirsten, you have
Thank
to
you.
run.
Yes. Thank
And
you. Bye-bye.
Jonathan, as well, thank you. If you have anything to say before you head out, now's your time.
Thank you, everyone. Thank you for having me and spending some time with us. If you guys ever have any loan-related questions, or if there's anything we can do to assist your associations, don't hesitate to reach out to us. We're happy to help take a look at things. Again, we only get paid when the loan closes. So feel free to utilize our knowledge. If we can help in any way, we're here to help with that, with any community that needs our assistance. And again, thank you to all the panelists. Thank you to all the guests, and have a good day, everyone.